Be seated. Let the record reflect the presence of the jury panel, Ms. Smith and counsel. Ladies and gentlemen, good morning. Sorry we're a little bit late starting. What almost always happens on the day of closing argument, I'm putting together the jury instructions and I figure out I left something out or something needs to come out and I'm scrambling around, and that's what happened this morning. So trying to make sure everything's exactly correct sometimes takes a little time, and it did this morning. So if you see any typos, they're actually in there on purpose to make sure that you're reading carefully to catch them. Let me talk to you a little bit about the scheduling for this morning. I'm going to read the instructions in a moment, and then we're going to start closing argument. I expect that the state's closing argument will almost certainly go into the lunch hour. How far, I'm not sure. So be ready for that, and then we'll take a break of about an hour for lunch, and then get into the defense closing argument and then any rebuttal by the state. So we're going to go beyond lunch hour to make sure we finish the state's closing argument at one time. So with that, we're going to go through the final jury instructions, the final instructions of law. I previously checked with counsel to make sure that our court reporter did not have to take down the instructions since they're in written form. Ladies and gentlemen, it is your duty as a juror to decide this case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You should not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Lawyers' comments are not evidence. In their opening statements and soon-to-be-made closing arguments, the lawyers have talked to you about the law and the evidence. What the lawyers said is not evidence, but it may help you to understand the law and the evidence. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Presumption of innocence, reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether the defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Multiple acts. The defendant is accused of having committed the crime of conspiracy to commit custodial interference in count 1. The prosecution has introduced evidence for the purpose of showing that there is more than one act upon which a conviction on count 1 may be based. Defendant may be found guilty if the proof shows beyond a reasonable doubt that she committed any one or more of the acts. However, in order to return a verdict of guilty to count one, all jurors must agree that she committed the same act or acts. It is not necessary that the particular act agreed upon be stated in your verdict. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not now on trial, or not on trial now. You should not guess about the reason any person is absent from the courtroom. Evidence of any kind. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant acting with the advice of an attorney. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the test for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Witness prior conviction. You have heard evidence that a witness has previously been convicted of a criminal offense. You may consider this evidence only as it may affect the witness's believability. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think the defendant is guilty just because of the charge. The defendant has pled not guilty. This plea of not guilty means the state must prove each element of the charge beyond a reasonable doubt. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Other acts. Evidence of other acts has been presented. You may consider these acts only if you find that the state has proved by clear and convincing evidence that the defendant committed these acts. You may only consider these acts to establish the defendant's motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or accident. You must not consider these acts to determine the defendant's character or character trait, or to determine that the defendant acted in conformity with the defendant's character or character trait, and therefore committed the charged offense. Clear and convincing evidence. Other acts must be proven by clear and convincing evidence. A party who has the burden of proof by clear and convincing evidence must persuade you by the evidence that the claim is highly probable. This standard is more exacting than the standard of more probably true than not true, but it is less exacting than the standard of proof beyond a reasonable doubt. In determining whether a party has met this burden of proof, you will consider all the evidence, whether presented by the state or the defense. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not, in and of itself, make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Separate counts. Each count charges a separate and distinct offense. You must decide each count separately on the evidence with the law applicable to it, uninfluenced by your decision on any other count. You may find that the state has proved beyond a reasonable doubt all, some, or none of the charged offenses. Your finding for each count must be stated in a separate verdict. Defendant's testimony. You must evaluate the defendant's testimony the same as any witness's testimony. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. Defendant's request to speak to an attorney is not evidence. You have heard testimony that Ms. Smith may have spoken to her attorney or was asking to speak to her attorney while speaking to Detective Ramirez. You may not consider that as evidence of any kind. No allegation regarding kidnapping of Gabriel Johnson. The state has not alleged that the defendant has committed the offense of kidnapping or otherwise participated in the disappearance of Gabriel Johnson on or around December 27, 2009. To the extent there has been evidence suggesting that such an allegation was previously made by the state and or Elizabeth Johnson, you are not to consider any such allegation in reaching your verdict in this case. Conspiracy to commit custodial interference. The crime of custodial interference requires proof that the defendant, number one, took, enticed, or kept from lawful custody any child entrusted by authority of law to the custody of another person or institution, or had joint legal custody of the child and took, enticed, or withheld the child from the physical custody of the other custodian, and, number two, knew or had reason to know that the defendant had no legal right to do so. The element of conspiracy requires proof that, number one, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and two, the defendant intended to promote or assist in the commission of such conduct, and three, the intended conduct would constitute a crime, and four, an overt act was committed in furtherance of such conduct. Child born out of wedlock. If a child is born out of wedlock, the mother is the legal custodian of the child until paternity is established and custody or access is determined by a court. Forgery. The crime of forgery requires proof that the defendant, with the intent to defraud, falsely made, completed, or altered a written instrument. Overt act for conspiracy. An overt act is any act knowingly committed by one of the conspirators in an effort to accomplish some object of the conspiracy. This overt act need not be criminal in nature, but it must be an act that tends toward accomplishment of the plan, and it must be knowingly done in furtherance of some object of the conspiracy. Intentionally or with intent to defined. Intentionally or with intent to, as used in these instructions, means that a defendant's objective is to cause that result or engage in that conduct. Intent, inference defined. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Included mental state, knowingly defined. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. Knowingly defined. Knowingly means that a defendant acted with awareness of or belief in the existence of conduct or circumstances constituting an offense. It does not mean that a defendant must have known the conduct is forbidden by law. Consideration of evidence of success of conspiracy. In considering the evidence relating to the offense of conspiracy, there may be liability even if the people involved do not succeed in accomplishing their common object. In order for a conspiracy to be proven, it is not necessary that the prosecution show that the conspirators succeeded. Mere association not sufficient for conspiracy. The fact that persons conduct themselves in a similar manner or associate with each other or assemble together or discuss common aims does not alone prove a conspiracy. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or other person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only the person's acts and statements. Let me read that again. You should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Acts and statements of co-conspirators. Acts or statements of any co-conspirator which do not further the conspiracy or which occur before its existence or after its termination may be considered as evidence only against the person making them. Okay, I'm not going to read to you the last page until after the closing arguments have been made, which means it's time for closing arguments. And the state, having the burden of proof, gets to go first and last. So, Ms. Andrews, you may proceed with your closing arguments.
May I have the screen?
You may.
Good morning. 5 weeks ago today, defense counsel stood right here before you, and she told you that this case was not about Gabriel Johnson. However, this case has absolutely everything to do with Gabriel Johnson. It has to do with Gabriel Johnson and his family, Logan's family. Logan was a father who was trying to make a life for his girlfriend and for his child. He was working, he was putting together a home, he was trying to raise his son. But then there was a plan. There was a plan by Elizabeth Johnson, and there was a plan by the defendant. And that plan was to remove Logan McQueary from the life of his child. The defendant wanted this child for herself. She wanted to make Gabriel Johnson her own, and she was going to do that at any cost to Logan McQueary. Her co-conspirator, Elizabeth Johnson, she had a different reason for wanting to take Gabriel Johnson away from Logan McQueary. She wanted to punish Logan. She wanted to make him mad. She wanted to get back at him for him making her mad. But together, they then conspired to take this child, who was born on May 3rd, 2009, away from Logan McQueary. Now on this date, actually prior to this date, Elizabeth Johnson and Logan McQueary talked about this unborn child. And Elizabeth Johnson didn't want to have a child, but they talked about it, and in the end, they decided they were going to have a child. And Logan McQueary decided at that point he was going to raise his child. And then he took his girlfriend and the unborn child out of state to look for a job. a job that he received. And he went out of state, but Elizabeth, she wanted to come back. And if you recall, Logan was on the stand. He told you about the morning sickness that Elizabeth had on that trip. But Elizabeth didn't like being out of state. She wanted to come home to her family. And so they came home to the family. And Logan paid a price for that because he was in violation of his probation. And he went to jail for violating his probation by leaving the state to go to a job. But while he was in jail, he was on work furlough. He was working to make money to provide for his family. He was paying for daycare. He was taking care of his child. He actually violated his work furlough so that he could go to the hospital the day his son was born. In the meantime, the defendant, starting in 2008, we can show the defendant wanted to have a child of her own. She was doing everything she could to make sure that she found a sibling for the child she already had. The first posting in September of 2008, she talks about adopting a child from China. We have no idea what happened to that child. In November of 2008, she posts on MySpace an ad for a surrogate. And in that ad, she indicates she wants somebody from California because the laws in Arizona of surrogacy are so weird. She then posts again the same day. Now remember, the defendant came in here, and she sat on that witness stand under oath, and she testified. And do you recall what she said? We weren't desperate to have a baby. Her husband said we weren't desperate to have another baby. But look at her own words. We want a baby so badly. We want to have a baby desperately. We are desperately looking and have not found the right one. My 3-year-old adopted daughter is getting antsy. These are all within the same day in November of 2008. In March 2009, the defendant posts to an unknown woman a posting offering to adopt this woman's baby based on what she put in the profile. And she tells this woman on MySpace, my daughter is almost 4 and she's desperate for a baby sister or a brother. And the woman responds, hey, I'm not giving up my child for adoption. I never give up my child for adoption. We're a very happy family. And the defendant, okay, I'm sorry, never mind. And then one day in June of 2009, the defendant meets Elizabeth Johnson. And this is a pair made for Logan, a pair made in hell, because this began what ended up being Logan McQueary's downfall in his ability to raise his own child. Now, the defendant testified that she saw Elizabeth Johnson at the airport, and she testified that she saw her with another woman, and that she appeared to be a 16-year-old girl, and that she approached her because she looked sad. And she talked about Elizabeth Johnson crying. Now, she never mentioned these comments to any of the times she spoke to any of the detectives. She never talked about the other woman or Elizabeth appearing to be a 16-year-old girl. But in fact, Elizabeth was a 24-year-old woman. And they talked. Now, we don't know what was said. We don't know specifically what was said because nobody was there except for Elizabeth Johnson and the defendant. So we have to rely on what the defendant tells us, assuming you believe the things that the defendant tells us. Now, at this point in time, the reason that Elizabeth Johnson was in the airport is because she had run. She was mad at Logan. She had run to her grandmother in Boston. She stayed there for a short period of time, and then she called Logan and said, I want to come home. And so Logan, not having the money, got the money from Elizabeth's grandfather, and he brought her home. And he brought Gabriel home. And she was coming home to Logan. She was coming home to her grandfather and her family when she met the defendant in the airport. And this is exactly what Elizabeth Johnson does. She runs. When she's mad at Logan, she runs. And then she comes home. Additionally, at this meeting, the defendant claims that the grandmother, Elizabeth Johnson's grandmother, and Elizabeth were trying to adopt out Gabriel. However, the defendant never, ever provided that information to the police. the defendant actually approached Elizabeth Johnson, and they had a conversation about adopting the baby. Although the defendant doesn't give us a whole lot of details about that conversation. Essentially, she tells us on the stand that the grandmother and Elizabeth were trying to adopt out the baby, but again, that's not something she ever told the police. So now she's testifying in trial that this is how adoption came up, because Elizabeth brought it up at that point. After Elizabeth Johnson met the defendant at the airport, the defendant becomes depressed. Now, she told two different stories, and in fact, I believe she testified that she wasn't depressed. And in opening statement, defense counsel told you she wasn't depressed, she moved on, she tried to adopt another baby. But what the defendant told police, she said her own words, "I cried for days when Elizabeth Johnson didn't call me." What the defendant told Logan McQueary on a phone call you heard in court and that's in evidence, I cried for months when Elizabeth didn't call me. Now at this point, Elizabeth and Logan, they have some problems and their relationship doesn't go well. In the meantime, the defendant meets Rachel Hoover in the Jack in the Box. And they talk about the defendant wanting to adopt Rachel's baby. Now, Rachel came in. She's a very sweet girl. She came in, and she told you, "I'm friendly. I talk to anybody." And she was pregnant, and she and the defendant had a conversation, and they talked about the defendant adopting her child. It turns out Rachel wants to give her baby up for adoption. The defendant wants to adopt a baby. Everything sounds like it's going to work out pretty well. So they go and they meet each other. They show up Rachel, Rachel's boyfriend Jacob, Rachel's children, Jack, Hannah, and the defendant all meet at an Einstein's Bagel. And that's where things get weird. That's where Rachel and Jacob become a little uncomfortable. Because, according to Rachel, the defendant doesn't want to use Rachel's lawyer. Now, if you remember, the defendant testified in trial that she told Rachel about a lawyer and offered to pay for it. But if you recall, the defendant's own attorney, her own adoption attorney, said that it's important for the person, the other party, to have independent counsel. And that he recommended that Rachel and Jacob have independent counsel. And Rachel and Jacob wanted to have independent counsel. And in fact, they eventually hired independent counsel. But the defendant didn't want to use that counsel. So the defendant came up with a couple of different plans. One of those plans, let's put Jack's name on the birth certificate. Now, where else have we heard that in this trial? The defendant later claims that Elizabeth Johnson wanted to put Jack's name on the birth certificate. But isn't it interesting that Rachel said the defendant wanted to put Jack's name on paperwork? She also said the defendant had an idea that if Rachel says she can't take care of the baby, then the defendant could adopt the baby. And she also said that Rachel could just abandon her baby, and then the defendant could go ahead and adopt her baby. Well, Rachel and Jacob, they don't like this plan, and so they meet in the bathroom. They sneak away, take Rachel's daughter to the bathroom, and they talk about the fact that they're a little uncomfortable about this meeting, and they don't know if they want to go through with this. But on December 8th, 2009, while this adoption is still pending, the defendant doesn't know that Rachel and Jacob have decided not to go through with it. On December 8, 2009, Logan moves out of Elizabeth Johnson's home. And he takes with him Gabriel Johnson because according to Logan, she says, "Take that thing with you." And so he takes Gabriel with him. And he goes to his grandmother's home. And then Elizabeth Johnson reports that Logan has kidnapped Gabriel Johnson. This is the first report in this particular case, in this particular time frame, where Elizabeth Johnson has alleged that Logan is the kidnapper. And Logan really doesn't have a choice. He has to return Gabriel Johnson back to Elizabeth Johnson. Then the defendant, on December 8, 2009, out of the blue, contacts the defendant about the adoption of Gabriel Johnson. This is the very last time that Logan McQueary has seen his son. On December 9, 2009, Gabriel is given to the Smiths by Elizabeth Johnson, the co-conspirator in this case. And then Elizabeth, the defendant, and Jack go to the Bank of America to sign temporary guardianship paperwork drafted by the defendant. Now, I want to point this out. We've talked a little bit about this temporary guardianship paperwork. But one of the things I want to point out, you heard from Ken Schutt, the defendant's lawyer, that he provided the defendant with a temporary guardianship paperwork for the adoption of Rachel Hoover's baby. And he provided that to us. And if you recall, I had him talk about it. And I'm actually going to show you down here at the bottom of the document. I'll show you the top. This is the document that Ken Schutt provided the defendant. For the record, it's exhibit number 235. Down here at the bottom of this document, there's a signature for the mother and the father. The temporary guardianship paperwork that the defendant drafted up for Elizabeth Johnson's baby, for Logan McQueary's baby, which is exhibit number 148. No signature for the father. So they go to the Bank of America and they sign that temporary guardianship paperwork, and the defendant now has Gabriel Johnson. Now, at this point in time, the Tempe Police Department is contacted. And they're contacted because Elizabeth Johnson has showed up at Logan McQueary's work. And she has accused Logan of kidnapping Gabriel Johnson a second time. Logan is with the police all day long. And when Logan's with the police, they're looking for Gabriel Johnson. They're contacting his family. They're looking all over for Gabriel Johnson. Elizabeth has told Logan that he needs to sign adoption papers. Logan has not had a conversation with Elizabeth Johnson about adoption papers since before Gabriel Johnson was born. On the same day, Detective Aguilera goes out to the defendant's home and he finds Gabriel safe and sound there. And on this occasion, Detective Aguilera tells the defendant what's going on. And on this occasion, the defendant is now on notice that Elizabeth Johnson is a liar. Because she now knows that Elizabeth Johnson has claimed Gabriel is somewhere else, and that he's not with the Smiths, and that Logan is being accused of kidnapping. On December 10th, 2009, Logan McQueary is told that Gabriel's found safe. He's not told who has him. He does not know who the Smiths are. So Logan and his father, they begin to do some research. They try and find these people who have their child. On December 11th, 2009, the CPS caseworker Alicia Shumway has contact with Logan McQueary and finds out he's on his way to court to file custody paperwork. And so Alicia then meets with Elizabeth Johnson. And when she meets with Elizabeth Johnson, Gabriel's not at the home. And when Alicia Shumway arrives at the home, and this is important because this is December 11th, 2009. When Alicia Shumway arrives at the home, Elizabeth Johnson doesn't let her in because she's selling her dogs. Now, Alicia Shumway can't recall if one dog or two dogs left at this point. She knows at least one left, and she knows there were no dogs in the home when she went inside. So at this point, Elizabeth Johnson has probably sold her second dog. Now, if you remember, there's some conversation between the defendant and the detective about these dogs. The defendant said she knows Elizabeth Johnson sold her dogs for her trip. Alicia talks to Elizabeth, says she wants to see Gabriel Johnson, and tells Elizabeth that Logan has filed for custody. At this point in time, Gabriel's still with the Smiths, and so Alicia contacts the defendant. And on the telephone, the defendant lies to Alicia Shumway as CPS. And if you recall Alicia's testimony, in fact, let's go to the defendant's testimony. Remember how she said Alicia has a lot of cases, maybe she doesn't remember this? Well, Alicia Shumway testified that she wrote her report shortly after this incident happened, and she put things in quotation marks to remind her what the defendant said. And what she said is the defendant told Alicia Shumway of CPS that she was just babysitting Gabriel while Elizabeth looked for a job. Now, we know at this point she's had Gabriel Johnson since the 9th. and that it is their intention, Elizabeth Johnson and the defendant, for the defendant to adopt this child. But she lies to the CPS caseworker. On the same day, Elizabeth Johnson posts to a friend on MySpace, "Hey girl, call my new phone number." And for your information, I didn't leave any phone numbers in this PowerPoint presentation, so we don't have to worry about alerting anybody. When I took out the phone numbers, I've indicated that there was a phone number there. But you have the phone numbers in the records that are admitted into evidence. But she says, Elizabeth Johnson says, on December 11, 2009, I gave the baby up for adoption. On December 13, 2009, Logan and Elizabeth are communicating on MySpace. What Logan tells Elizabeth is not a threat. He's not yelling at her through MySpace. He's not angry at her. He says, I am sorry the way things are, but I think it's for the best. We tried and tried to make things work. On December 14th, 2009, Alicia Shumway is able to meet with Logan. Logan now learns about the Smiths for the first time. At 1:30 in the afternoon, Alicia Shumway met with the defendant, Gabriel Johnson, and Elizabeth Johnson. While she's there, now remember what the defendant said about this conversation? The defendant claims that Alicia Shumway would not let her speak. Now, you've listened to several different interviews between the defendant and Detective Ramirez and the defendant and some of the other detectives. You've watched the defendant sit on this witness stand, and you've seen her attorney barely able to control her. You've watched the defendant on cross-examination with me and seen me barely able to control her. Yet somehow Alicia Shumway has the power to keep this defendant from speaking? Find that hard to believe. But that's what the defendant said. And so she sat there and she watched as the CPS worker confronted Elizabeth Johnson about her lies, about the fact that she was now changing her story about this adoption. Because what Alicia Shumway said is that on this occasion, Elizabeth Johnson told Alicia that she wasn't giving the baby up for adoption. And if you recall, the defendant testified that Elizabeth Johnson, the night before this meeting, had told her she changed her mind. That is the first time this detective has ever heard that statement. And the same time period, while the defendant is meeting with Alicia Shumway, she decides that Alicia Shumway is ugly and mean, this particular caseworker. And Alicia Shumway tells the defendant, stay out of it. Stay out of this custody between these two parents. On December 14, 2009, after the meeting with CPS, the defendant doesn't take Alicia Shumway's advice. What she does instead is she goes to court and she helps Elizabeth Johnson, because now at this point, on this day, Elizabeth Johnson has been served with the custody paperwork that Logan McQueary filed. The defendant, according to her own statement on cross-examination, talked to Craig Cherry that morning. And according to the defendant's testimony, she was joking with Elizabeth Johnson about putting Craig Cherry's name on the court document. Because this defendant has a great sense of humor. She's joked a lot during this case while Gabriel was missing. She laughs a lot and she jokes a lot. She's joking with Elizabeth Johnson about putting Craig Cherry's name on the document. And the defendant asked to use Deanne's husband on the document. Now, there's a disagreement between Deanne and the defendant about when they talked to each other. The defendant claims she talked to Deanne the night before when they were drinking. Deanne says that the defendant called her from court. The defendant also denies that she asked Deanne to use her husband's name on the court paperwork. However, she's never really provided any good reason why Deanne would come to court and testify to that. Why would Deanne say that if that didn't happen? So she goes to court with Elizabeth Johnson after Alicia Shumway says stay out of it, and she helps Elizabeth Johnson fill out paperwork. And then she puts on the paperwork Craig Cherry's name as a potential other father. Now, you heard from her adoption lawyer. Ken Shutt came in and he testified. And he testified about what he told the defendant about what to put on that paperwork. He told her to use a fictitious name, and he told her to do that because Elizabeth Johnson is afraid to put the real father's name because apparently that person may know Logan McQueary and it might cause some problems. But he also told the defendant, you need to make sure you tell the judge why you put a name on there. He didn't tell the defendant to find some real person to pretend he was the father so that he could have a DNA test. Now, if you recall, there's a statement from the defendant about it wouldn't hurt Craig Cherry if someone showed up at his door because he doesn't have a wife. But the defendant puts Craig Cherry's name. She doesn't listen to her attorney's advice. And if you recall also when Ken Shutt testified, he said the reason for that is if the defendant wanted to adopt this child, they would have to provide notice to the father. And if Logan McQueary is not the father, they got to find the father and provide that father notice. But that wasn't the defendant's intention. She doesn't want Logan to have the child, and she doesn't want anybody else to have the child. She wants to have the child herself. And so she puts the name of somebody who could not be the father, because then there's a DNA test. If Logan's not the father, then great, no problem. If Logan turns out to be the father, then she's got to deal with that at a different point. But if you recall what she told Deanna Ayla, is that she wanted to cause DNA testing to buy more time. She wanted to buy more time, not because she felt there might be some other father out there and we need to find out if Logan's really the father so we can make sure we give notice to the real father. No, so that they could buy more time. And she talked about that, and she talked about the context of putting stress on Logan during this child custody case. On December 15th, 2009, there are more conversations between Logan and Elizabeth on MySpace. He's not threatening her. He's not accusing her. Logan says to Elizabeth Johnson, please don't fight me on this. Let me take care of Gabriel. I can try and give him a good life. And you even said you can't take care of him right now. I want to see him so bad. Don't do this because you were mad at me. I can take care of him. And Elizabeth Johnson responds, and she doesn't say, stop threatening me, stop, abusing me, stop making my life miserable. She says, I understand completely. I just want the best for Gabe. That's all I want. He doesn't deserve to be in the middle of a custody battle. So on December 16, 2009, Logan and Elizabeth get together. And they have a romantic night together, and then they agree to joint custody. But somewhere between December 16, 2009, and the next day, December 17, 2009, you know that there's a phone call or a conversation, some sort of communication between the defendant and Elizabeth Johnson, because somehow it's agreed upon that the defendant will bring Gabriel to court on that day. Now, according to the defendant, she was supposed to meet and have lunch with Logan and his father. Now, we've heard a lot about Elizabeth Johnson in this case. She's not really the kind of person who has lunch. The defendant may be the kind of person who has lunch. Logan and his father denied that they ever had any agreement that they were going to have lunch with the defendant. They didn't even know they were going to be there. They showed up to court because they wanted custody. So they're at the court date. Logan and Elizabeth are present. Logan's father is sitting behind him in court. It's a public courtroom. Nobody is excluded from the courtroom. You've heard the judicial assistant testify to that. Paternity is established by agreement. Elizabeth Johnson does bring up another potential father, and the judge tells her the presumption is that Logan's on the birth certificate, he's the father. You want a DNA test, you can pay for it. But right now, the presumption is Logan's the father. Now, unfortunately, the night before, Elizabeth Johnson and Logan agreed to joint custody, but when they showed up at this court date, the judge is asking Logan about what he put in his petition. And then we know that there was some sort of communication between Elizabeth Johnson and the defendant. In this particular hearing, the judge explains a parenting conference, and you heard testimony from John Johnson, the judicial assistant, about what that is. And you actually heard testimony from the defendant herself, about a parenting conference that took place that she's aware of in another case. And this parenting conference is intended to provide the court with all the information he needs to make custody determinations. And he tells Logan and Elizabeth not to leave without signing paperwork saying that they're getting the information on the parenting conference. On December 17, 2009, Logan tries to explain to the judge why he called CPS. He tries to tell the judge the defendant gave the baby away to some people that Logan doesn't know. But he's cut off because the judge has to make some quick decisions in this first hearing. There's going to be a parenting conference and all this information is going to come out. So Logan didn't get the chance to explain to the judge on this particular hearing why he had called CPS. The judge does, however, order joint custody, and Elizabeth and Logan agree on that, and Logan is supposed to have Gabriel Johnson on Sunday. He's also supposed to have Gabriel Johnson through Christmas Eve. Now, on this particular occasion, the defendant claims that Elizabeth Johnson has no paperwork. Now, in the hearing, you hear the judge tell them to obtain something before they leave. She also claims that they're supposed to have lunch. We've already talked about this, but what she told the police as well on this particular date is she indicated that they were waiting outside the courtroom. Courtroom, not courthouse. And that Logan and his father walked right past Gabriel and didn't even talk to him. And how could a father do that? How could a father walk right past his son and not even talk to him? However, when we got to trial, the testimony is a little different. The statements that the defendant made to the detective have now changed. Now they're outside the courthouse, and Jack is parking the car with Gabriel and Hannah in it. Now remember, Frank and Logan, they don't know who the Smiths are. They've never seen them. They don't know that they're going to be there, other than the statement Elizabeth Johnson made in court that Gabriel's coming to court. They don't expect to see them, but they come out and Frank sees a woman talking to Elizabeth Johnson. And he explains that this woman appears to be upset with Elizabeth, and he describes that she's doing something like this. And he finds out later that that's Tammi Smith, the defendant. He doesn't see Jack Smith. He doesn't see Gabriel. Logan doesn't see Gabriel. And they don't walk right past Mad. Frank says, Logan, let's stay over here. You wanted to have a cigarette anyway. And they stand there for a little while, and then they leave. Neither Frank nor Logan saw Gabriel Johnson on that day, but the defendant claims they walked right by him. December 18th, 2009. On this particular date, you heard testimony from Detective Galbraith. Elizabeth Johnson, at 10:05 in the morning, went to a bank in Tempe, Arizona, and cleared almost all of the money out of an account that she had, all but $5 and change. And then later that day, at 5:55 p.m., Elizabeth Johnson clears the rest of that account, the $5 and change. And that bank where she cleared that money is minutes away from the church where she met the Smiths to obtain Gabriel Johnson at 5:55 p.m. Now, both the Smiths testified that they met Elizabeth Johnson somewhere around 7 o'clock. So the question is, what was Elizabeth Johnson doing minutes away from this church between the time that she cleared her account and supposedly met with the Smiths about an hour later? Now, this is important. We've talked a little bit about it, and you probably weren't thinking what the relevance of this is, and I'm going to tell you. The defendant testifies about a document she typed up for Elizabeth Johnson on this particular occasion. And the document she says she typed up is a document that, according to her, Elizabeth Johnson wants her to type up. And the document essentially tells Logan that he can only have one bottle of formula, one diaper, a couple of diaper wipes, one blanket, and one sleeper. And it specifies the judge's name, who supposedly ordered visitation according to this document. So clearly the defendant is aware of who the judge was in the case. And then it has a signature. But if you recall, Elizabeth Johnson has sold her dogs. She's cleared her bank accounts and she leaves the state after obtaining Gabriel Johnson. Why would she ask the defendant to type this up? It's because she didn't. This was part of the defendant's plan to stress Logan out and to gain custody. That's why it was typed. And if you recall, she testified at trial that the reason she typed it up is because Elizabeth Johnson's printer was broken. But that's not what she told the detective. In fact, when she was talking to the detective, she said, I wonder why she didn't type that up herself if she had a computer. But here at trial, her story changed. And now it's because, Elizabeth Johnson didn't have a printer, therefore she asked me to type it up. But it doesn't make any sense that Elizabeth Johnson would ask for that document. So on this particular occasion, the Smiths meet Elizabeth Johnson, and they give her Gabriel Johnson. And Elizabeth Johnson takes off. She leaves town to San Antonio, and it's undisputed that she left town to San Antonio on her own. But at this particular time, the defendant sees in Elizabeth Johnson's car a GPS device, but she doesn't remember to tell the police about that until January 7, 2010. On this same day, Elizabeth Johnson calls Logan McQueary and tells him he will never see Gabriel again. And Logan, at this point, he has done everything right. He has done everything he could do. He takes the baby when Elizabeth tells him to take the baby, and he gets accused of kidnapping, so he returns the baby. He then moves out, goes to work, and gets accused of kidnapping when the Smiths have the baby. He files a CPS report, he files for custody, he files an order of protection, and on December 18, 2009, when Elizabeth Johnson tells him he's never going to see his son, he calls the court again. And the court says, come to court on Monday if you don't get your son on Sunday when you're supposed to. Now, during this time frame, the Smiths have Gabriel Johnson between the 9th and the 18th. Now, Logan has filed for custody on the 11th. During this time frame, they change his name. They change Gabriel Johnson's name to Jacob. They save a file on their computer with photographs on it. In the interview with Officer Duarte, which is admitted in evidence, you can hear Jack telling the officer that. And then the defendant told Detective Ramirez that same thing during the search warrant. So during the 9 days that they had Gabriel Johnson, they changed his name. And according to them, it's because Elizabeth Johnson told them that they could. The 2 days, they had Gabriel Johnson 2 days prior to Logan McQueary filing for custody. On the 14th, they went in and filed forged court documents. And on the 18th, they gave up this child they're now calling Jacob to Elizabeth Johnson on the 18th. On December 20th, 2009, it was the Sunday that Logan was supposed to have Gabriel Johnson for the first time. Again, Logan is trying to do everything right. He follows his father's advice. He takes his father with him. He takes a recorder. He walks up to the trailer. He's looking for Elizabeth Johnson. She's not there. This has been admitted both on disc and the recorder itself for evidence. He's trying to find Elizabeth Johnson. She's not there. He has no way to reach her. On December 21st, 2009, Logan files for full custody of Gabriel Johnson, and it's granted, and a hearing set on December 28, 2009. Logan calls the Tempe Police Department and asks them to assist him in going back to the location to attempt to obtain Gabriel. But they go back and nobody's there. Now on December 21st, Logan finally locates a number for the defendant and her husband. Now keep in mind, you heard testimony that the Smiths tried to find Logan McQueary at the 99-cent store he worked. Now this is December 21st, 2009. If you recall, on December 9, 2009, at the 99-cent store where Logan worked, Elizabeth Johnson made a big ruckus and claimed that Logan McQueary had kidnapped the child. If the Smiths had shown up at that 99-cent store and said they have some information regarding Gabriel Johnson and they need to speak to Logan McQueary, someone would have contacted Logan. But instead, Logan contacts the Smiths, and he calls up the defendant at her work number that he's located, and they have a conversation. And he also talks to Jack on this particular occasion. Now, there are several phone calls between December 21st and December 22nd between Logan and the defendant and Logan and Jack. Logan McQueary on the 27th gave his recorder to the police, and they impounded the recorder and they downloaded the items off the disk. Those do not contain the phone calls from December 22nd, 2009. We don't know why. We don't know what happened to those phone calls. But we'll talk about those phone calls when we get to December 22nd, 2009. But first, there's some messages between Logan and Elizabeth. Now, Logan's mad. She tells Logan, Elizabeth is mad. She tells Logan, you don't care about me or us or our family. You only care about yourself. You treated me like your enemy instead of the woman you love and made your son. You were so quick to put yourself as single and take my pick down to start your new life and ditch me, so that's what I'm going. And the message kind of cuts off there. Essentially, she's mad at Logan because she thinks he's cheating on her. She thinks he's ignoring her, that he's gone on and moved on with his life. But she doesn't accuse him of threatening her. She doesn't accuse him of violence. Logan responds. Well, the defendant then posts a MySpace to Elizabeth Johnson at this point, and she's now looking for Gabriel. And she's looking for Gabriel because she wants to know where he is. She's concerned. We don't dispute that. The defendant and Logan then continue to talk on December 22nd, 2009. If you recall the defendant's testimony during these phone calls, they continued to bond with Logan. However, the defendant tells the police, and she testifies at trial, that she was telling Logan he needed to sign adoption papers because that's what Elizabeth told her. Now, if that's true, if that fact is true, if she was telling Logan that because that's what Elizabeth wanted her to tell Logan, that in and of itself is conspiracy. Because she is telling Logan McQueary that Elizabeth Johnson will not return with his son until he signs adoption papers. But the defendant claims to the detective that she's laughing when she tells Logan McQueary this. And she says, and she admits it on the stand on cross-examination, finally, but she tells the detective that she's laughing. The detective tells her it's not a laughing matter. Logan's not laughing about this. There is now a phone call, again, on December 22nd, 2009, between Logan and the defendant. Again, they're having more conversations. Now, according to the defendant's testimony, during these conversations, Logan told her that his father and he talked about adoption and were considering it. But you heard testimony from both Logan and Frank McQueary that they talked about adoption, and Logan did not want to do adoption. He was not interested in adoption. And there's no reason for Frank or Logan to testify otherwise. On the same date, Elizabeth and the defendant have a text message conversation. The defendant is trying to reach Elizabeth. She's trying to find out where Gabriel Johnson is. They also send a message and tell her, call me, it's too much to tell you over a text. This is important because there's a lot of text message communication between Elizabeth Johnson and the defendant. There's also a lot of MySpace communication between the two of them, and there are a lot of telephone calls. The difference is we have the text messages, we have the MySpace communications. The only people who know what was said in those telephone calls are Elizabeth Johnson and the defendant. The only people who know what was said during those conversations that were in person are Elizabeth Johnson and the defendant. And what the defendant is claiming that's occurring in those phone calls, those conversations that nobody else can hear, is that Elizabeth Johnson is saying that Logan's threatening her, that Elizabeth Johnson is saying that she wants Logan to sign adoption papers, that Elizabeth Johnson is saying all these things, but yet none of those is backed up by the information we do have. None of those statements are backed up by the text messages and the phone calls. Logan McQueary, however, his statements are backed up because other than the phone calls on December 22nd, 2009, between he and the defendant, which very little is in dispute about, and the phone call that Logan testified he got from Jack when he was at a Denny's, all of the other communications we have. Logan's communications with Elizabeth Johnson, his conversations with her, you've heard those in court. The MySpace pages, you've seen those. So what we don't know is what is said between the defendant and Elizabeth Johnson while they participate in this conspiracy. There's some more conversations, text messages between the defendant and Elizabeth. Some of the content we don't have on the text messages. There's some more conversations. The defendant and Logan are exchanging communication. They talk to each other probably for about 2 hours total between December 21st, 2009 and December 22nd, 2009. And the phone calls on the 21st you have. You've heard those in court, and you can hear them again if you'd like. But now, according to the defendant, she is laughing when she tells Logan that Elizabeth Johnson wants him to sign adoption papers. But then she sends him this text. Now, if she had already told him on the telephone that Elizabeth wanted to sign him adoption papers, why would she have to say the same thing in a text message? And if she was laughing, and if it were a joke, why would Logan respond the way he did? So the text message she sends to Logan on December 22nd, 2009 at 1:30, after having communication with her, is, "Can we get together tomorrow morning to talk with you and your dad? I'm afraid she'll be gone forever because she doesn't want to go to jail for kidnapping." Now, the defendant is the first person to mention jail and kidnapping, and she mentions it to Logan McQueary. Is it possible Logan McQueary said to the defendant on the telephone, Elizabeth Johnson could be charged with kidnapping and go to jail? It's possible. We don't have those recordings, so we don't know for sure. But was he wrong? Is that a threat? Elizabeth Johnson has left the state with his child when there's a custody order in place. If Logan McQueary told the defendant that, that's fine. It's probably true. Logan denies that he said that, however. The defendant continues to tell Logan, doesn't trust you or your dad. The only way she'll come back is if my attorney faxed the signed papers to her so she won't get in trouble. And this statement is really important. And Gabriel be with us. The defendant is still trying to get Gabriel Johnson at this point. She wants Logan to sign adoption papers to get Gabriel Johnson back here so that they can then have. Logan's mad. He's mad at this point. Now remember, they supposedly discussed this in a telephone call. However, now this communication is happening through text. Logan's mad and says, no, Monday when she fails to appear, the judge will issue a warrant for her arrest, and anyone who has helped her will be subject to arrest as an accessory. And they are going to issue an Amber Alert for Elizabeth and the baby. I am not signing any adoption paperwork. I want my son. Now, in this point in time, Logan is telling the defendant, December 22nd, 2009, that if you're helping her, you will be charged as an accessory. Because Logan's upset, because he's feeling now the pressure that he talked about from the defendant and trying to get him to give up his rights to his own child. There are some more communications back and forth between the defendant. The defendant sends a very nice text message back to Logan McQueary and says, I will tell her this. God bless. And then she also tells Logan McQueary that Elizabeth needed to have a happy Christmas and she'll come back and she'll be in court. So now she's sending nice text messages to Logan that she knows that he has on his phone and that he could show to anybody. But she's also admitting that she's in communication with Elizabeth Johnson and she's relaying messages back and forth. There are some more conversations. Well, on December 22nd, 2009, the defendant tries to reach Elizabeth, and she actually does. They talk for 23 minutes and 30 seconds. And I probably should explain how I have these on there. The first number on there is the Arizona time. The second number on there is the military time. The third number on there is San Antonio time. The message is Elizabeth to Tammi. That's who made the text message, who received it, and the last number on there is how long the telephone call was. If it's a text, it will say text at the end. If it's a MySpace, it says MySpace at the end. If there's a number at the end, it's a telephone conversation, and that indicates how long they talked. So on December 22nd, 2009, Elizabeth Johnson and the defendant talked for 23 minutes and 30 seconds. There's another call, probably didn't go through, and then they talk again for 2 minutes and 45 seconds. On December 23rd, 2009, there's communication back and forth between the defendant and Elizabeth Johnson. Now, during these communications, we know from testimony, we know from the defendant's own statements that there are conversations about changing jurisdiction, that there are conversations about going to Tennessee. December 24th, 2009, Christmas Eve, the day that Logan is supposed to have his son for Christmas. He's supposed to have him through the Christmas Eve. Gabriel still can't be found. The defendant texts her friend in Tennessee, Jolene Hare, and asks for Janet Morris's phone number because she knows a good adoption attorney. Now, the defendant has an adoption attorney. She talked to the adoption attorney about Elizabeth Johnson. She talked to the adoption attorney about the adoption. And her adoption attorney told her, you can't adopt this child. If the father's not going to sign off, you can't adopt this child. And then the adoption attorney thinks that Tammi Smith is done. He thinks she's done. She no longer wants to adopt this child. She does not call her own adoption attorney, the one she retained on December 8, 2009, and ask him about the ability to adopt this child by going to another state. She doesn't do that because he's already told her she can't adopt this child if the father doesn't sign off. That same day, the defendant gets Janet Morris's phone number. She converses some more with Elizabeth Johnson. Again, we don't know what they're talking about in this particular conversation, except we know from defendant's many statements they're talking about changing jurisdiction and going to Tennessee. On Christmas Day, there's some more communication both by text and by telephone between the two. Very short phone call on the telephone. Perhaps it wasn't a call that went through, maybe it's a message. Then she texts and they respond and they say Merry Christmas. Now I want to talk to you a little bit about December 24th, 2009. There are some comments the defendant made to the detective about being concerned about what Elizabeth Johnson would do to Gabriel while she's out of state. However, the defendant herself provided what's exhibit number 172 to the police, which is Elizabeth Johnson's MySpace page. And essentially what's on the MySpace page from December 22nd, 2009 to December 24th, 2009 are good things. Elizabeth Johnson is posting good things because she's in San Antonio, Texas. She's hired a babysitter. We know that from testimony. She's looking for a job. We know that from testimony. And she posts on December 21st, 2009, my Bubba's learning to crawl. And her mood is accomplished. She posts on December 23rd, 2009, where there's a will, there's a way. On December 24th, 2009, she posts where there's a will, there's a way, and her mood is amused. And on December 24th, 2009, the last post, excited to start my new life, mood is happy. Now we know Logan McQueary is not calling Elizabeth Johnson. He's not texting her. He's not able to reach her. He's leaving her alone because he knows Elizabeth Johnson runs. That's what she does. She runs. And he knows that she'll probably come back. Now he's filing for custody. He's in court filing for custody. He's looking for her, but he's not calling her. And if you recall, on December 21st, 2009, Jack tells him, let us handle it, be a man. The same conversation he insults him about a child growing up in the trailer, because I guess not everybody can be a child prodigy. But Logan McQueary, up to this point, has not called Elizabeth Johnson. And so she's happy, she's living a life, but the person who's contacting Elizabeth Johnson while she's in San Antonio, Texas, incessantly is the defendant. And she's having conversations with her. She's telling her about a condo in Tennessee. She's telling her about a home in Tennessee. And then she gives her Janet Morris's phone number in Tennessee. And she tells her, call her so she can give you legal advice. You need to know. Then call me and we'll talk, Tammi. Again, call me so we can talk. So nobody knows what we're saying to each other. Logan then calls Elizabeth Johnson on December 26, 2009. Now, you have heard this call. This call isn't in evidence. In this phone call, Logan does not threaten Elizabeth Johnson. In fact, Elizabeth Johnson is the one who's angry. She's very upset. She talks about the fact that Logan is going on Facebook. He's playing around. She's mad because he's contacted her roommate. She says that he's pathetic. He's living with his family. He should be ashamed of himself. He's acting childish. He's playing games. He's trying to get attention. She comments the judge won't see it his way. She talks about him threatening her friends, but there's no evidence of Logan threatening anybody. She's concerned about the report that the car is being stolen, that her grandfather's car is reported stolen. And then she gets mad. She's mad at Logan McQueary during this phone call because she says, you had my phone number and you didn't call me. Elizabeth Johnson isn't claiming that Logan's calling and threatening her. She isn't claiming that Logan is bothering her, and she's mad because he's not calling her. She's mad because he's not trying to communicate with her. She's trying to get back at him, and he's ignoring her. That's what she's angry about. She specifically says, she tells Logan, you don't care about Gabriel, you don't care about us. Good luck, Logan. You will never see him again because I'm allowed to move, I'm allowed to get a job, I'm allowed to have my own life, and you can't stop me. So good luck and bye. And she ends the phone call with Logan McQueary. That is the only phone call that Logan McQueary has with Elizabeth Johnson. And he's not threatening her. She's the one who's angry. So on December 26, 2009, there's a 30-minute phone call between Elizabeth and the defendant. And then Elizabeth calls Janet Morris. It appears that perhaps she left a message. And then Janet Morris calls Elizabeth Johnson back. And they talk for 49 minutes and 46 seconds. After this phone call on December 26, 2009, there's an 8-second phone call to Elizabeth Johnson's friend Soren, which appears to have not gone through. And then the next time we hear from Elizabeth Johnson is December 27, 2009. The defendant's trying to reach Elizabeth, but Elizabeth isn't responding. Elizabeth, on December 27, 2009, instead texts Logan, I killed him. And she sends some pretty awful things to Logan McQueary about what she's done to their son. And then she responds to the defendant. She says, no, I'm not okay. I'm upset. I'm scared. The defendant says, call me. I'm here for you. What's going on? Has done something. Now, I believe that what she meant to say was, has he done something or has Logan done something? Because she's implied that Logan would hurt Elizabeth Johnson, even though there's no evidence to that. And now here are the texts that come right after that. From Elizabeth Johnson to Logan. She calls him a coward bitch, a pathetic loser, run to daddy. She says, you will never see Gabriel again. I made sure of that, and you can spend the rest of your pathetic life wondering about him. These are awful text messages from Elizabeth Johnson to Logan McQueary that we don't accuse the defendant of participating in. Because the defendant doesn't want Gabriel Johnson hurt. She wants Gabriel Johnson to be her son. She wants Gabriel Johnson to be Hannah's brother. Elizabeth Johnson did this part on her own. And at this part, Elizabeth Johnson has essentially gone away from their plan. And she's acted on her own. Elizabeth Johnson sends more awful texts to Logan. In the same time frame, the defendant is trying to reach Elizabeth Johnson. She's asking her to call. She's offering up information about her own life. She's telling her, we can change your life. You can be happy. You don't have to, your life doesn't have to be defined by your past. Johnson tells the defendant, it's too late for me. I'm going to be charged with kidnapping, get a felony, and go to jail. And the defendant is surprised by that statement. She's not like, oh no, we've told you before that's not going to happen. She's surprised. She says, no, you're not, exclamation point. Who told you? Who said that? Exclamation point, exclamation point, exclamation point. Up until this point, she's been accusing Logan of telling Elizabeth Johnson this information, yet she is surprised to hear it from Elizabeth Johnson. Elizabeth Johnson says to the defendant, "Your lawyer told me that yesterday." And there's some confusion because the defendant thinks maybe she's talking about Ken Schutt. And it's cleared up that she's not talking about Ken Schutt, she's talking about Janet Morris. Elizabeth tells the defendant, "I can't come back. I won't go to jail. I'd rather die. Plus, you could get charged with aiding and abetting." This is what Elizabeth Johnson tells the defendant after this 49-minute phone call with Janet Morris. There's some more conversation. The defendant tells Elizabeth that she got off with her lawyer. She didn't get served, so she doesn't have to go to court. Now, Ken Schutt didn't say that to the defendant. She didn't tell the defendant, "You can tell Elizabeth because she didn't get served, she doesn't have to show." He said, "Tell Elizabeth she needs to show. But if she can't show, she should send a lawyer, or she should at least try and call in." The lawyer didn't give advice that she doesn't have to appear because she hasn't been served. But that's what the defendant tells Elizabeth Johnson. And then the defendant tells Elizabeth Johnson, "Keep your hotel receipts." She has offered Elizabeth Johnson a place to stay when she comes back, but she tells her to keep your hotel receipts. And Elizabeth Johnson wonders why. And the defendant says, "I don't want them thinking you were here before the first court date because I told the police, Logan, in court you weren't." But now the defendant is trying to cover her tracks, and she's making self-serving statements to Elizabeth Johnson to obtain evidence that would keep the defendant from being charged with perhaps what Janet Morris said, aiding and abetting. There's some more conversations between the defendant and Elizabeth Johnson, and the defendant is trying to get Elizabeth Johnson to come home at this point. Because at this point, she now knows that Elizabeth Johnson has claimed to have killed Gabriel Johnson. Because while Logan McQueary is at the Tempe police station talking to Officer Snell calls the defendant. Detective Ramirez talks to the defendant on that day, and eventually later in the evening, the other officers arrive at her home. She's concerned. She's admittedly concerned about this child, and she wants them to come home because Elizabeth Johnson didn't follow the plan to go to Tennessee. Elizabeth Johnson looked up Tennessee in her GPS and decided it was too far to go, so she didn't go. This text message here is kind of interesting because the defendant tells Elizabeth Johnson, "We can't help you break the law." Now, she's already been accused of possibly being aiding and abetting in this case, and so now she's making self-serving statements to try and protect herself. She's trying to get the defendant back. She talks about what happens to Gabriel Johnson. She's asking for them to call. She wants to hear his voice. There's further phone calls where she's trying to reach Elizabeth Johnson. Elizabeth Johnson says, "My cell phone's not working." That's what she told the sergeant as well when the sergeant called her that the calls were dropping. And then on the same particular day, 3:17 in the afternoon, after she has received this text message from Elizabeth Johnson that says Janet Morris told her that she would go to jail for kidnapping and that the defendant could be charged with aiding and abetting, Tammi Smith, the defendant, has a conversation with her daughter. She tells her they're trying to get Elizabeth Johnson to come back. And then she tells her daughter, her ex has been telling her she's going to prison for kidnapping and an Amber Alert was sent. He scared her to death. This is just a couple of hours after she received a text message from Elizabeth Johnson telling her who exactly is it who told her that she was going to be charged with kidnapping charges. The woman that the defendant put her in touch with. But she's happy. She's having a new life on Christmas Eve. But on December 27th, she's not so happy anymore because she had this phone call with Janet Morris, the defendant's friend, on December 26th. Again, the defendant is trying to reach out to Elizabeth Johnson, but she says, "Please let me know that you both are okay. I don't know if Logan found you and hurt you or something." Now, Logan McQueary is at the police station reporting reporting that Elizabeth Johnson has killed his son. The defendant knows that because when she talks to Elizabeth Johnson, she tells him that you sent things to Logan saying that you had done things to Gabriel Johnson. So she knows this. On December 28, 2009, Logan tells the defendant to stop calling him. She calls him to see if Elizabeth Johnson showed up at court. She then claims to the detective that Logan has threatened her. You have that phone call. That's admitted in evidence. We've played it. The phone call says, it's Logan on the recorder. He's identifying what the recording is. He says, calling Tammi and Rich. They just called me at 3:14 p.m. Answer, hello? Question, hello. Answer, hi Logan, did she show up? Question, no, she didn't show up. Answer, okay, do you have anything else? Logan, no. Answer, since yesterday, no. And Logan says, now remember, he's claimed that she's threatened him, or she's claimed that Logan is threatening him in this phone call. Just wanted to let you guys know, basically you guys have pretty much caused this by helping her and done other things, you know. And, I don't want you guys calling me anymore. And I don't want you guys, and you guys are interfering with the ongoing investigation. If you continue doing what you're doing, so, and the defendant cuts him off. And she says, you know what, I don't need to listen to this. I've heard the opposite from the lead detective, Detective Aguilera. And Detective Aguilera is not the lead detective on this case. He went out to the Smiths on 2 occasions to find Gabriel Johnson. So I don't need to listen to this. We've done everything we could possible to get her back here. And Logan responds, no, you didn't, and don't call me back. That's the same phone call that she claims to Detective Ramirez that Logan was threatening her. In the same phone call that she has with Detective Ramirez, she makes some interesting statements. Detective Ramirez asks her, would you be willing to assist in the prosecution of Elizabeth Johnson? And the defendant says, well, I'm not going to lie for the police. Defendant didn't ask, or Detective Ramirez didn't ask Tammi Smith to lie for anything. Why would she say that? It doesn't make any sense at all. So there's some more communications on December 28, 2009. She has some more communications with her daughter, the defendant does, and she's trying to reach Elizabeth Johnson. And apparently she doesn't listen to Logan's message where he says, stop calling me. And they have some communications, and that 1 minute 15 second phone call is the one I just read to you. And then on December 28, 2009, Tammi sends a text to Detective Aguilera, and she tells Detective Aguilera, have you heard anything about baby Gabriel? The father, Logan, called me yelling and threatening me that you were going to put us in jail for helping her. I'm not scared. So now she's misrepresented this phone call, not only to Detective Ramirez, but to Detective Aguilera as well. And then she sends a text, and she tells her daughter, again, the father called, he tried to threaten me and said it was my fault for helping her, and that's because he may be in trouble for threatening her and caused this. Now she knows. She is one of 2 people who knows what's on this phone call because she doesn't know that Logan recorded it and provided it to the police. And yet she's telling everybody that it's Logan's fault. On December 29, 2009, you've heard this interview. The defendant had the first interview with Detective Ramirez. This is the time where she claims Logan made threats to Elizabeth. She claims Logan made threats to the defendant. And then she tells the detective about meeting Elizabeth in the airport and being devastated for days. She talks about how they were going to stress Logan for the child custody. Now there's some communication between the defendant and Elizabeth Johnson on December 29, 2009. She talks about how she's distraught. She loves Gabriel. She wants him to come home. This goes on. But she says in the message, which is interesting, to Elizabeth Johnson on MySpace, and now at this point she knows the police are looking at her communications because they came out on December 27, 2009 and obtained them. And at this point she tells Elizabeth Johnson, as we told you all this time, if you do the right thing, everything will work out for the good. A self-serving statement. Why would you say that? That doesn't make any sense. And then she talks about Detective Aguilera, and she says that Detective Aguilera doesn't like Logan and his dad and what they did to you. Well, Detective Aguilera, when he testified, denied making those statements. There's more conversations between the defendant and Elizabeth on MySpace. And she's trying to get her to come home. I mean, at this point, December 29, 2009, she's trying to get her to come home. Elizabeth has said she killed Gabriel. Now, this is a message from Elizabeth to the defendant. And Elizabeth tells the defendant, Gabriel and I are fine. In fact, I got a full-time job under a fake name, and the owner is very understanding of my situation and is willing to help me get new IDs and stuff. Why would Elizabeth Johnson tell the defendant that if the defendant wasn't in support of Elizabeth Johnson getting a fake name, a fake ID, and changing her identity? Why would she send this message to somebody unless she knew the person would support her? Again, there's more conversation between Elizabeth Johnson and the defendant on MySpace. She says, I had to tell you what was happening. You were good people. And Elizabeth tells the defendant that she wanted to let her know she was safe, but she's concerned she can be traced by her messages. And in fact, that's true because she's located, because of this MySpace post, in Miami Beach. And she doesn't have Gabriel with her. And now, the defendant doesn't know that she's located, doesn't know that Gabriel's not with her, and she's still communicating with her, and she's happy for her, and she's glad she told her that Gabriel was safe. And now she's asking for pictures, because she wants pictures so she can know that Gabriel's safe. And the defendant lets Detective Aguilera know she's heard from Elizabeth Johnson. New Year's Eve. December 31st, 2009, again the defendant is interviewed in her home by Detective Ramirez and Detective Ryberg. This is a phone call this is an interview we did not play, but we admitted, and you can listen to. But if you remember Detective Ramirez's testimony, it was about an hour. I believe it's about 58 minutes. The defendant claims in a text that during this interview, the FBI held her in a chair for 4 hours. That didn't happen. On this particular occasion, she tells the detective she talked to Deanne about Elizabeth. She also tells the detective that Elizabeth talked about putting someone else's name on the birth certificate and that Elizabeth suggested putting Jack's name. The defendant also tells the detective that Logan and his dad's decision on adoption of Gabriel was up in the air. This is a text message she sent to a friend talking about the FBI holding her in a chair for 4 hours. On January 2nd, 2010, the defendant leaves a message for Detective Ramirez about false adoption paperwork that would take 5 days to process. Then they have a conversation on January 3rd, 2010, and now the defendant tells Detective Ramirez about the plan during the week of December 22nd to force Logan to give up his rights by Elizabeth leaving the state with Gabriel Johnson. And then the defendant again suggests to Detective Ramirez filing false adoption paperwork, and Detective Ramirez turns that down because of the inappropriateness of the suggestion. January 3rd, 2010. Now remember, this is January 3rd. There were phone calls and conversations between Logan and the defendant December 21st, December 22nd. The defendant tells Logan tells the defendant what Elizabeth Johnson is about. He talks about that she's shaking the baby. He talks about the criminal damage. He talks about Elizabeth being unstable and Elizabeth's grandfather and brother trying to get her help. They have conversations like this. Yet on January 3rd, 2010, after she's told the police that she no longer is trying to get Gabriel Johnson to adopt him, she sends this text message. There's a question from a person in an out-of-state phone number. Topic of adoption papers to verify that you guys were going to adopt Gabriel. My boss always asks for proof. The defendant responds and says, you can talk to my attorney, Ken Shutt. The plan was for her to sign 5 days after him so he couldn't change his mind or he could end up getting the baby. Then the defendant tells this person that she signed the temporary guardianship papers that we still have, and the police have lots of copies of it. My guess is that the other family had that notarized. And the response back to the defendant is, do you think she went through an adoption agency? You should contact CPS to make sure you can provide foster care for baby when returned. January 3rd, 2010, she clearly knows that Logan McQueary wants the baby. She's already talking to the media, and she's telling everybody she's trying to get that baby returned back to his father. She tells this person, we are starting classes on January 12th, foster classes. This is a response to the foster classes. But it takes about 3 months or more. And the person says still contact them, CPS, just in case. And then the defendant says to this person, I guess I will do that tomorrow. I have a friend that is a caseworker for CPS in Tennessee. We adopted Hannah and she was the caseworker. Maybe she can put in a good word. The person responds, if not, they might send him to a random home, and the defendant responds back, or to the dad and grandpa. So in this conversation, January 3rd, 2010, she's concerned, she's trying to get this baby still for Logan and his father. January 4th, 2010, she calls Judge McVeigh on the voicemail. She leaves a voicemail. She wants the judge to order guardianship to her while the parents get it together. And in that message, she says, so we can get that baby. That's admitted into evidence. You want to hear that again, perhaps a little better than we heard it here. You can hear it as many times as you want. The judge has his judicial assistant urgently call the police because this is a message. Now you remember John Johnson. He talks to people all the time. Parties, unrepresented parties, people who call up. But this one caused them to urgently call the police. On January 4th, 2010, the defendant declines to do an interview because she's got an early media appointment. We find out later that that media appointment is where they're going to have a reporter come in and talk to Elizabeth Johnson at Robert Johnson's home. She also tells the detective on this day that she is thinking of sending fake adoption paperwork to Elizabeth in Florida, and the detective tells her not to do that. On January 7th, 2010, the defendant calls Detective Ramirez and leaves her a message. Detective Ramirez had told her that she was not going to be available because Detective Ramirez is in Miami picking up Elizabeth Johnson. She's in Miami Beach. But because the defendant is going on the media saying that the police are unresponsive to her, Detective Ramirez calls the defendant back from her hotel room in Miami Beach, Florida. On this particular phone call, the defendant now blames a San Antonio reporter for the call to Judge McVeigh. She also tells the detective for the first time about the GPS she saw in Elizabeth's car. And then she talks about the plan to adopt Elizabeth Johnson so that now Gabriel can belong to her as the grandchild. And in fact, it's her intention, according to what she said to the detective, for Elizabeth Johnson to live in the casita while Gabriel Johnson lives in the home with the Smiths, presumably under the name Jacob. She then talks to the detective about changing jurisdictions during that week of December 22nd to December 27th. And in the conversations that she had with the detective, they progressed from one night while drinking to 24 hours to a couple of days. She also says she wants to find the baby to clear her name. On January 10th, 2010, we hear a conversation between the defendant and Craig Cherry, which is captured on the wiretap. Conversation they don't know we're hearing. And Craig Cherry, he's concerned because the police are showing up and they're questioning him about why his name is on a document. And he tells the defendant, they're gonna connect us. And she talks to him again on January 11, 2010 about the court paperwork. And she tells him about her plan, that she'll just tell the police Elizabeth put down the name. And then she calls two detectives, not one, but two detectives, and leaves them a similar voicemail. And she tells both detectives, she flat out lies to them, and says Elizabeth Johnson put Craig Cherry's name on the court document. And she's only doing this because Craig Cherry is freaking out because the police are showing up to talk to him. And then she talks to Detective Ramirez, and now she's trying to put it off her. You should look into the grandparents, as though the Tempe Police Department isn't doing everything they can to find this child, including looking into the grandparents, including putting a wiretap on the grandfather's phone. But the defendant, she's going to suggest it on January 13th, 2010, because this will get the focus off of me. Detective Ramirez testified, as you heard, that they did in fact look into the grandparents. On the 14th, the Detective Duplessis picks up the court paperwork, and at this point in time, the defendant shows up to the police station and she does an interview, which she claims was in the basement, and she also claims it's an interrogation, which is probably a fair statement, because at this point, Detective Ramirez knows that she is a liar, and she is going to interrogate her. But you actually heard that interview, and you heard the conversation between the detective and the defendant. And you can tell from the words the detective gave to the defendant that she gave her every opportunity to come clean. She gave her every opportunity to provide all the information she could on the case. During this interview, the defendant first claims that Elizabeth wrote Craig Cherry's name on the family court document. So now she's lied to Detective Ramirez twice and Detective Thompson on his voicemail once. She finally admits to writing Craig Cherry's name on the document. And that's not until the detective puts the document in front of her and after she has already asked her for a handwriting sample. So now the defendant's putting two and two together. Oh, I have this document. She's asking me about my writing. She's already asked for my handwriting sample. I better fess up to it now. And she admits. And then she claims she forgot. She forgot she wrote all of this information, all of the information I showed you from Alan Kreidel's report on this court document. She forgot until the detective put it in front of her. She also tells the detective in the same interview that she spoke to Elizabeth often while researching changing jurisdictions, because she didn't just research it. There's nothing wrong with researching something, but then she researched it and she told Elizabeth about it and she gave her a place to go. She gave her a condo, she gave her a home, she gave her the renewal house. And then she claims that she suggested Craig's name only after Elizabeth Johnson wanted to use Jack's name. And then she tells Detective Ramirez, this is the only lie I've told to the police. And my question is, how many lies do the police have to hear before the defendant becomes a suspect? She is the last person, she and her husband are the last two people who saw Gabriel Johnson in the state of Arizona on December 18th, 2009. And now she knows that she's put false information on the court paperwork in a custody agreement. How many lies do the police have to hear before they start looking into the defendant as being involved in the disappearance of this child who they have yet to find at this point? She goes out, right out of the police station, the defendant goes out and talks to the media that she apparently must have invited to the police station, and she tells them, she admits she was helping a friend. In helping a friend, perhaps that's conspiracy. Because the defendant mentions email communications on her computer, the detective, she freaks out. She's like, ugh. She writes a search warrant. Now, I can pretty much guarantee you, I think we can assume Detective Ramirez had better things to do on January 14, 2010 at 9 o'clock at night than to go all the way out to the Smith's residence, which was about an hour away from the police station, and search their home after repeatedly having conversations with her. But it's the defendant's own statement that caused her to go out there. And a search warrant is conducted at defendant's home, and you heard how awful that search warrant was from the defendant with all the helicopters flying around and all, the media helicopters. And you hear how awful it must have been for her, being held with all these officers, even though she asked the detective to sit on the floor with her in a room. They go to the search warrant, they obtain her phone card. That's the same phone card we looked at to obtain some messages. But then the police then obtained them through the phone records as well. They also obtain the hard drive. They don't take her computer. She has a business to run. And the police let her keep her computer so she can use that to run the business. They let she and her husband keep their phones. On January 14th, 2010, Elizabeth Johnson is interviewed by Detective Thompson. That's what he was doing while Detective Ramirez was talking to the defendant. Now, there's a jury instruction that says you can't use Elizabeth Johnson's statements against the defendant in this case that happened after the conspiracy. So anything that was not part of the conspiracy, you can't use that. But this information came in because this is part of the police investigation that they did. On January 14th, 2010, there's a phone call between the defendant and detective before the search warrant. In this phone call, the defendant tells the detective that she talked to Elizabeth Johnson about the situation in which they obtained Hannah, and Hannah's father defaulted because he didn't show up for court, which is an interesting conversation to have with somebody when you know Logan McQueary is the one who filed custody proceedings in this case in the first place. In this phone conversation, the defendant admits to Detective Ramirez that she was hiding Elizabeth, but at this point she claims at that time, I thought she had full custody. The defendant also says to Detective Ramirez that she did not tell the police on December 29th or December 31st about changing jurisdictions because it has nothing to do with Elizabeth Johnson's disappearance. Now, Elizabeth Johnson is out of state with Gabriel Johnson. Nobody knows where he is. And the defendant is telling her to go to Tennessee. But somehow that's not relevant to an investigation about a missing child. During the interview, the defendant claims she and Jack were consuming alcohol, and that Jack then called his son in Tennessee to talk about the condo. And then she started researching attorneys, and she admits to telling Elizabeth about the condo. She also claims that she was too tired to remember the details of conversations with Elizabeth. We have yet to hear the details about any conversation she had with Elizabeth Johnson. She can remember details about what they were cooking during a Saints game or what kind of drinks she had at a Christmas party. She can remember details to the point where we have to stop her and remind her what the question is. But when asked what conversation she had with Elizabeth Johnson, she can't remember the details. During this conversation with Detective Ramirez, she claimed that Rachel Hoover and Jacob Roberts only wanted money for their baby. She tells the detective that she's not desperate to have a baby, and she tells the detective that Elizabeth Johnson is going underground to a domestic violence shelter. She also tells the detective, she admits to the detective, that she told Deanne about changing jurisdictions to Tennessee, and she told Deanne about Renewal House. But yet the defendant claims that Deanne is lying about the other things that she testified to. On January 21st, 2010, that's when the detective finds this document that clearly shows that the defendant is trying to stress Logan. And on January 22nd, 2010, there's that confrontation call between Elizabeth Johnson and the defendant. Now, the police have information provided by Elizabeth Johnson. They have to follow up on that. They have to do their job. What this confrontation call tells you, if you recall, the defendant testified many times. She told the detective many times that Elizabeth Johnson manipulated her. And you heard testimony both on her direct examination and on cross-examination about her life experience, about her certifications, about her traveling to Africa and being a preacher, about her job, about her businesses. And you heard her on that telephone call with Elizabeth Johnson. It is clear that the defendant was not manipulated by Elizabeth Johnson, this young 24-year-old girl who has her first child. The defendant is the one with the life experiences. The defendant is the one who has been through not one, but 2 child custody cases. Yes, she said she was manipulated by Elizabeth Johnson. You can clearly tell by that call she was not. On January 28, 2010, the police received Alan Kreidel's report about handwriting. It's not really that important to the police at this point because they have an admission, but it does provide more information about some of the other things the defendant wrote on the document. And what's important, and I pointed it out during trial, is she didn't just write Craig Cherry's name. She also wrote, there are 2 potential fathers. Although we were together at the time of birth, Logan signs the birth certificate. And she wrote that on the same page that says Superior Court of Arizona in Maricopa County. February 2nd, 2010, the final interview between Detective Ramirez and the defendant. The defendant again claims she didn't remember writing Craig's name on the document until the detective showed it to her. She denied talking to Deanne from court, but she admits to talking to Deanne the night before. She also claims that she was drinking and joking when she talked to Deanne. Again, she has quite the sense of humor. She claims that because she was drinking the night before, she doesn't remember too much about the events of the day she went to the courthouse. Now remember, she didn't just go to the courthouse. She drove Gabriel Johnson to Elizabeth Johnson's home to meet with CPS. She drove Elizabeth Johnson to a parenting conference to a parenting class, and they went to court to fill out paperwork. But yet, when asked about the specific details of that, she tells the detective, I don't remember those because I was drinking the night before. She also then, at this point, tries to put the detective on Logan's tail for forgery. She's trying to deflect again off her own actions. The plan in this case was to pressure Logan McQueary. What she said to the detective was, the way we were going to get him to possibly sign adoption papers was to use our attorney and make Logan be responsible for back child support, current child support, and appear for current visitation. She would use her attorney and make sure that Logan was arrested each time. Then hopefully Logan would say, screw this, and it's not worth this. She also knew that the defendant had left, that Elizabeth had left Arizona initially in December of 2009 to force Logan to sign those adoption papers. And she still wanted to fax those adoption papers to Elizabeth Johnson so that Logan would not have custody. The defendant contacted Logan. He tried to meet with him and his dad. Logan declined. She tried to offer up an idea to Phoenix PD to have Logan sign a document that looks like adoption paperwork. She suggested in a text that Elizabeth would return to Arizona if Logan signed the paperwork. She called Judge McVeigh to be part of the scheme, and she admitted to forging a document. She researched changing jurisdictions, and she put Elizabeth in contact with Janet Morris. She also learned for the first time that Janet Morris is the one who told Elizabeth she would go to jail for kidnapping. She tells Elizabeth about Renewal House in Tennessee. She tells Elizabeth about the condo in Tennessee. She tells Elizabeth about the home in Tennessee. And Elizabeth looks into going to Tennessee. She puts an address in her GPS. The charges in this case are conspiracy to commit custodial interference and forgery. To conspiracy to commit custodial interference, you need to find that she conspired, the defendant conspired, knowing or having no reason to know she has no legal right to do so, to take, entice, or keep from lawful custody any child entrusted by law to the custody of another person, or had joint legal custody of the child and took, enticed, or withheld the child from physical custody of the other custodian. Now, Elizabeth Johnson is the one who had joint custody. Elizabeth Johnson is the one she conspired with to interfere with Logan's rights. She wanted Logan to pay back child support. Now, remember, there is no back child support. Logan moved out December 8, 2009. She wanted to put him in court and give him jail time. She wanted him to sign adoption papers, and she took his signature out of the temporary guardianship paperwork. She also wanted her to go to Tennessee. We've talked about this several times. These are the overt acts that she did in relation to the conspiracy, because you have to find that she did overt acts. The forgery, that happened on December 14th, 2009. Now, I have heard from a couple of people that the defendant is not guilty of forgery because she didn't falsely write someone else's name. That, in fact, can be a forgery. If you write someone else's name and you don't have permission to do so, that can be a forgery. That's not the forgery in this case. Sure, the defendant wrote Elizabeth Johnson's name, but there's no indication she didn't have Elizabeth Johnson's permission to do that. The forgery in this case is that she falsely made, completed, or altered a written instrument. She put false information on a written instrument. That's all we have to show that she intended to defraud by doing that. And in this particular case, by listing Craig Cherry as a potential father, she wanted someone other than Logan to take DNA testing so that it would take more time. It was her intent to defraud. Now, she claims she didn't know she was in a courthouse. She claims that she didn't know that was court paperwork. Now, we heard testimony from the detective that it's pretty clear she was in a courthouse. And I showed you the document. It's pretty clear it was a court document. But according to her, she claims she thought it was just going to Logan. Well, guess what? She's still guilty. Because even if it was going to Logan, she's still, with the intent to defraud, falsely made, completed, or altered a written instrument. And so she's still guilty even if you believe her. She filled out 2 different lines about that, and she's confronted with the document. We talked about all of this already, so I'll go ahead and move on. Deanna Ayla. These are other schemes, and you're going to get, well, you got the jury instruction on page 5 that talks about other act evidence. What other act evidence is it helps you determine if the defendant had a motive or an intent or a plan or a scheme or an opportunity to commit the offense. And the other act evidence that we're talking about, and there's an instruction because you judge that differently than the acts that go to the crime. You have to find, by clear and convincing evidence, that these happened, and you have to find that they were used for those intent, motive, opportunity, common plan, common scheme. But those specific acts, those other acts, are Deanne's testimony about the defendant wanting to put her husband's name on the document, Deanne's testimony about the defendant wanting to use her husband's sperm to create a child, the conversations with Jacob Roberts and Rachel Hoover about the adoption of that baby, and her schemes with Rachel Hoover about how she can get that. And I might point out that the defendant testified on the stand that she called Rachel Hoover. She claims it was before trial, but she says she called Rachel Hoover because she wanted Rachel Hoover to be her witness. But she also testified really nothing about Rachel Hoover other than that the attorney sold their baby. And she actually used the word sold our baby. And she gave inconsistent statements about how much that attorney supposedly sold that baby for. But during her testimony, she didn't address not once what Rachel Hoover said about the plan. Not once did she talk about Rachel Hoover's allegation.
Judge, Your Honor, Ms. Smith's testimony, commenting on Ms. Smith's testimony and what she did not say.
Overruled. I know what you're objecting to. It's overruled. She can fairly go in a limited way to what was said and not said when she already addressed the topic. So the objection's overruled.
So she didn't address Rachel Hoover's allegations. The allegation that she wanted to put Jack Smith's name on the document, the allegation that she wanted Rachel Hoover to abandon her child, or the allegation that she wanted Rachel Hoover to say she couldn't take care of the child so the defendant could adopt her. The call to Judge McVeigh, that's other act evidence that you can consider as far as motive, intent, opportunity, common plan, or scheme. Lack of mistake as well. The surrogacy, the conversations that she had, the ads she posted about surrogacy, the fact that she was trying to avoid Arizona's weird laws, the fact that she had a surrogate, used a surrogate, and she's unclear whether or not her husband even knew about it. The random stranger that she contacted on MySpace. Lies and inconsistencies. You heard Detective Ramirez testify yesterday about some of the inconsistencies she caught during the defendant's testimony. I'm not going to go over all of those with you. You guys were present yesterday when the detective testified. But we talked about how she lied to Detective Ryberg and Detective Ramirez about Logan's criminal history. She accused Logan of armed robbery, armed burglary, and said he'd been in and out of prison several times. And then on the witness stand, when I cross-examined her on it, she said, well, I don't know how to read those things. Yet she's going on the Nancy Grace show talking about Logan's criminal history. But she claims here in trial she doesn't even know how to read it. She tells the police it was the only lie about Craig Cherry was the only lie. But that's not the only lie she told the police. She'd never used the word John Doe, the term John Doe, when she talked to the detective. She never said her attorney told her to put a John Doe on the paperwork. The first time John Doe was mentioned, as Ken Shutt testified, he told us about it when we interviewed him on May 8th. And then the defendant testifies to the words John Doe for the first time. She lied about using Craig's name on the court document. She lied when she said Elizabeth wrote the name. She lied to her daughter and the police about who told Elizabeth Johnson she was facing kidnapping charges. She lied and she changed her story when she talked about Logan and his character, depending on who she was talking to. One minute he's a great guy and he's going to get the baby. The next minute he's a felon and he's abusive to Elizabeth Johnson, depending on who she was talking about. You couldn't keep track on what her feelings were about Logan McQueary. She lied to Detective Ramirez about Logan threatening her in that phone call that I read to you earlier. She lied about her desire and intention to adopt Gabriel Johnson after Elizabeth left the state with him. You saw from text messages on January 3rd, 2010, she still intended to adopt the child. She was starting foster care classes. She also told Dave Hutchins that once court proceedings were started, she was finished. But that's not true at all. She knew court proceedings were started when Logan filed the paperwork on December 14th, 2009. She admitted that she said she might have embellished something in court or made my ex-husband look worse in the child custody case involving her ex-husband. She claimed the FBI held her in a chair for 4 hours on New Year's Eve, and she lied to Alicia Shumway of CPS when she told Alicia Shumway she was only babysitting Gabriel while Elizabeth looked for a job. She claims when she met Elizabeth Johnson in the airport that she just listened to Elizabeth Johnson. But we know from her many statements to the detective, from her testimony in the court, this defendant never just listens. And she claims that Alicia Shumway of CPS would let her talk. But we know that the defendant doesn't let anybody keep her from talking. We know that we've presented more than sufficient evidence to you for you to come back with a verdict of guilty on both counts in this case. Thank you.
Thank you, Ms. Andrews. Okay, ladies and gentlemen, we're going to take our lunch break. We're going to make it an hour, so at approximately 2:05, we're going to come back. Be here ready to go then. We'll have the defense closing at that time. Until then, remember the admonition. We'll see you in an hour.